Hello and welcome to our ethical lawyering class. Today we are going to be talking about the duty to preserve client confidences or the duty of confidentiality. So in this class we are going to be looking at the ethical rules relating to the duty of confidentiality. The duty of confidentiality or the duty to preserve client confidences is a duty that is very vital and important in the lawyer-client relationship. And this is important both for the lawyer, for the client, for the legal profession, and of course for the justice system. It is important for the lawyer because for the lawyer to be able to competently represent the client, the lawyer will need comprehensive and candid information about the client and the client affair in order to be able to provide the client with adequate representation. So a lawyer whose client is honest in disclosing confidential information about the client that relates to the representation will be more competent and equipped to represent the client than where the client is economical with the information relevant to its affair. So that's why this duty is important to the lawyer. On the other hand, to the client, it is important, the duty is important to the client because it is very difficult for a client to share their personal and confidential information to the lawyer where such information is relevant to the representation by the lawyer. This is because the client may be cautious about that information being disclosed or used in a way that they do not authorize or permit. So the duty of confidentiality is important so as to provide the client with assurance that the information the client provides to the lawyer in the course of the lawyer-client relationship, that such informations will be adequately protected. So it is in the interest of the legal profession as well as justice system that information shared by the client in the course of the lawyer relationship is vigorously protected. The legal principles as well as the ethical principles that apply to the protection of this information or information shared by the client in the lawyer-client relationship or information obtained by the lawyer in the lawyer-client relationship, it's what we are going to be talking about today. That is, we are going to be talking about the legal and ethical principles that apply to protect this information. So, at the end of this class, you should be able to understand the meaning and the principles behind the duty of confidentiality. But most importantly, you should be able to tell the differences and similarities between the duty of confidentiality, that is the ethical duty of confidentiality, and the legal principle of solicitor-client privilege. We are also going to see the justifications for the ethical duty of confidentiality. So, like I stated at the beginning of this video, lawyers need confidential information about the client in order to be able to competently represent the client. And the client, on the other hand, also needs assurance that the information they disclose to the lawyer in the course of the lawyer-client relationship will be adequately protected and not used or disclosed against their wish. So, the legal principle which serves to balance these competing interests or to balance the interest, the diverse interests of the lawyer and the client in the information needed to be able to carry on this relationship is the ethical duty of confidentiality and the legal principle of solicitor-client. That is the legal principle of solicitor-client privilege. So we are going to start by looking at the duty of confidentiality. What exactly is the duty of confidentiality? Well, the duty of confidentiality is an ethical obligation that is imposed on a lawyer or imposed on lawyers to prevent the unauthorized use or disclosure of information concerning the business and affairs of the client, which is acquired by lawyers in the course of the lawyer-client or solicitor-client relationship. This duty is clearly provided for under the rules of professional conduct, in this case, the Law Society of Alberta Code of Conduct. And what is important about this rule is the fact that it applies not just to lawyers, but also staff and employees of the law firm. Now, it is important to note that although this duty, the Law Society, this duty is imposed by the Code of Conduct, and we all know that the Law Society does not have jurisdiction, generally does not have jurisdiction over non-lawyers, for example, staffs, non-lawyer staffs and employees of the law firm. But it is important to note that the Law Society indirectly controls the non-lawyer staffs and employee of the lawyer by imposing an obligation on the lawyer to oversee or to adequately supervise these non-lawyer staffs. So the duty of confidentiality, which is imposed directly on the lawyer by the Code of Conduct, indirectly extends to staff and employees of the lawyer's law firm, because under the rules, the lawyer has an obligation under the rule to ensure that their staff and employees who are non-lawyers also uphold to this duty. That is the duty of confidentiality. So the duty of confidentiality is provided for in Rule 3.31 of the Law Society of Alberta Code of Conduct. And that rule clearly provides, it has a general rule and it has its exception. So for the purpose of this class, we're going to be looking at the general rule. We'll look at the exceptions in our subsequent classes. So the general rule is to the effect that a lawyer at all times must hold in confidence all information concerning the business and affairs of a client acquired in the course of the professional relationship and must not divulge any such information. So that is the general rule with regards to the duty of confidentiality. That is the duty on a lawyer not to divulge any information, confidential information about the business and affairs of the client acquired in the course of the lawyer-client relationship. Part of the duty of confidentiality, Rule 3.32 of the Law Society of Alberta Code of Conduct goes further to impose further obligation with regards to the use of confidential information acquired in the course of the lawyer-client relationship. And that rule provides that a lawyer must not use or disclose a client or former client confidential information to the disadvantage of the client or former client, or to the benefit of the lawyer or a third party without the consent of the client or former client. So a lawyer is prohibited from using information acquired in the lawyer-client relationship to the advantage of the client or for the benefit of personal benefit of the lawyer or a third party. So this rule kind of seems to set the parameter or the limit within which information obtained by the lawyer in the course of the lawyer-client relationship can be used by the lawyer. So a lawyer is generally prohibited from disclosing that information to a third party, whether that is to the detriment of the client or not. You cannot disclose the information to the third party or divulge such information. Then Rule 3.232 goes further to cover situations where such information are used to the disadvantage of the client. It is prohibited to use the information to the disadvantage of the client, and the lawyer also is prohibited from using those information to his own advantage or to the advantage of a third party. So in discussing the duty of confidentiality, it is important, of course, to once again identify the client. And The client under the rule, of course, includes persons who sought the lawyer's professional knowledge, even though the lawyer did not subsequently represent that person. And of course, this brings to your mind our discussion on prospective clients under the rule. So, client here is not just a person that retained the lawyer to provide legal services, but also includes a person who has sought the lawyer's legal advice but did not eventually end up retaining the lawyer. So information disclosed or confidential information disclosed at that earlier stage of seeking the lawyer's legal advice, such informations are also bound by the duty of confidentiality, irrespective of the fact that the lawyer did not go on to represent the client or the client did not go on to retain the lawyer. Now, like we stated earlier, it's also important to emphasize again that this duty is owned by all members of the lawyer's law firm. Now, the definition of law firm here is important. The law firm here is defined broadly to include lawyers who practice law independently but from the same premises or office premises. So, of course, this will include sole practitioners who have like a shared office space, use the same support staff, and maybe probably the same office facilities. So the fact that they are practicing, I mean, the fact that they practice in the same premises, even though they practice independently, the definition here of a law firm include or cover such situation. And of course, this is important because in a situation where lawyers who practice independence of one another share the same common staff, there is the likelihood or high likelihood that confidential information will also be shared among these lawyers, either deliberately or inadvertently. So it's not surprising to see the reason or the rationale behind the definition of law firm in this case to include even lawyers who practice law independent of one another but in the same environment. So lawyers must also extend the duty of confidentiality to other lawyers, employees, and even students who are employed by lawyers during the course of their employment. And of course, this is because these individuals, of course, come into possession of this confidential information of the clients. And when they come into possession of the confidential information, it's also important to see to it that these individuals maintain the confidentiality of this information. So whether these individuals are lawyers or not is immaterial. And one of the best way for lawyers to enforce this rule with regards to their employees is to ensure to it that there is an undertaking in their contract of employment which binds these individuals to maintain the confidentiality of all confidential information that comes in their possession during the course of, not just during the course of their employment with the law firm, but even after the employment has ceased or after they have ceased to work for the lawyer or for the law firm. So important to also highlight the commentary number 5 in rule 3.315. Commentary number 5 in rule 3.315 imposes the duty of confidentiality or extend the duty of confidentiality to include to include the fact that a person has retained a lawyer or a person has consulted a lawyer with regards to a particular matter. The implication is that the fact that a client has consulted me to seek my legal advice on a particular matter is confidential information. I cannot disclose that fact. It is protected by the duty of confidentiality. Now, also note the fact that the part of this commentary, which is to the effect that the fact that a lawyer has been retained by a client is also confidential information. That means as a lawyer, you cannot go out to say XYZ is my client or ABC is my client. That is confidential information. However, that confidential information, there could be an implied waiver to disclose such confidential information. For example, if XYZ retains me to commence a legal action in court on their behalf, there is no way I can commence that legal action in court without making public, in public documents, the fact that I am representing XYZ. Of course, that has to be that information has to be entered in commencement documents, which I have to file in court. And this commencement document filed in court are public documents. So yes, when a client retains you to commence a legal action on their behalf, they are impliedly waiving or consenting to the disclosure of the fact that you are retained to commence that legal action. Another situation also that we can look at in the context of Rule 3.31, Commentary 5, it's when a debtor hires a lawyer to recover some debt. Sorry, when a creditor hires a lawyer to recover a debt from a debtor. Of course, for the lawyer to be able to approach the debtor either in writing to recover such debt, the lawyer will have to disclose the fact that XYZ, Mr. Creditor, has retained me as his counsel for the purpose of recovering this debt from you. So these are situations where the lawyer can disclose the fact of their being retained by a client. But generally, the fact that a lawyer has been retained by a client, or the fact that a client has consulted a lawyer to seek legal information on a matter or legal advice on a matter, are confidential information which comes within the broad scope of the duty of confidentiality, and for which the lawyer and his staff or employees are under obligation to protect the confidentiality. Considering the very important nature of confidential information in the lawyer-client relationship and the need for such information to be kept in confidence, lawyers must be careful about sharing confidential information obtained in the course of their lawyer-client relationship. They must be very careful about sharing this information with third parties. And these third parties here, of course, include even family members, their spouse. This is important because these third parties are not under any ethical duty to keep such information confidential. And this is different from, support staffs. Support staffs are under ethical, well, they are not under ethical duty, but they are bound by the terms and nature of their employment to keep such information confidential, especially where this has been made part of their contract or an undertaking in their contract. So a lawyer can conveniently share this confidential information with staffs for the purpose of providing legal advice or advancing the client's claim. But in most cases, lawyers do not need to share this confidential information with family members in order to advance the client's claim or the client's interest. In most cases, this information is shared with family members as part of gossip, which of course goes a long way to destroy the lawyer-client relationship. So lawyers must keep in confidence confidential information obtained in the course of their lawyer-client relationship, and they must guard against disclosing this information to third parties, including their spouse. Now, it is important to note that the lawyer-client relationship, it lasts forever. The duty of confidentiality in the lawyer-client relationship lasts forever, not the lawyer-client relationship. So the duty to preserve the confidence of the confidential information obtained in the course of the relationship lasts forever. It continues to last even after the relationship has ended. And it is immaterial how the lawyer-client relationship ended, whether it ended amicably or it ended dramatically. The lawyer is under obligation to continue to uphold the confidentiality of information obtained in the course of their relationship. So for further details on the duty of confidentiality or the ethical duty of confidentiality, I will invite you to generally consider the rule in the Law Society of Alberta Code of Conduct, that is Rule 3.31 and Rule 3.32. So, an important aspect of the duty of confidentiality, which we're going to be talking about today, is the solicitor-client privilege. Now, the solicitor-client privilege, you can view the solicitor-client privilege as as a subset within the broader legal duty, within the broader ethical duty of confidentiality. Not just as a subset of the broader duty of confidentiality, but even as a sort of a highly fortified or sophisticated subset of the duty of confidentiality. And I refer to it as being highly fortified because of the high standing the solicitor-client privilege has come to acquire in our legal system. So, to start with, what is a solicitor-client privilege? Well, solicitor-client privilege is or was a common law rule that metamorphosed to an evidential rule and recently to a constitutionally protected principle which generally protects the disclosure of confidential information provided by client, confidential information exchanged between the client and the lawyer in the course of the solicitor-client or lawyer-client relationship. Now, take note of the two-way traffic here with regards to solicitor-client privilege. So that privilege protects information from the lawyer, from the client to the lawyer, as well as from the lawyer to the client. The exchange of information in the course of seeking legal advice, that is the client seeking legal advice, or the lawyer providing the legal advice to the client. All information exchanged in this course or in the course of this two-way traffic is protected by a legal principle known as solicitor-client privilege. The solicitor-client privilege applies to all communications, written and oral communication between a lawyer and client in the course of in the course of seeking or provision of legal advice between the lawyer and the client. So this principle applies to prevent the disclosure of information to third parties. And when we're talking about information here, we're talking about information exchanged by the lawyer and client in the course of the lawyer-client relationship. So the solicitor-client privilege prevents the disclosure of such information to third parties, and third parties here include both opposing parties to investigators and even agents of the government, for example, law enforcement officials. Now, it is important to distinguish solicitor-client privilege with another similar legal privilege, which is known as litigation privilege. Litigation privilege applies to documents, that is, documents prepared by counsel for the dominant purpose of litigation. So this will include, among other things, maybe documents prepared by research prepared by counsel in the preparation of litigation, or expert report prepared by counsel for use in developing their litigation strategy, which is not meant to be evidence in court. So litigation privilege kind of serves to shield the lawyer's preparation of litigation from the opposing party. So this privilege differs from solicitor-client privilege. Solicitor-client privilege covers written and oral communications between the lawyer and the client in the course of seeking and providing legal services. So, having discussed the broader duty of confidentiality, the broader duty of confidentiality, and of course the unique or subset of that duty, which is the solicitor-client privilege. Going further, we are going to consider the differences as well as the similarities between the ethical duty, the broader ethical duty of confidentiality, and the more specific legal principle relating to uh, solicitor-client privilege. So let's start with the differences between the duty of confidentiality and solicitor-client privilege. Now, we're going to look at these differences in first by looking at the origin of these two. The solicitor-client privilege uh, was a common law of common law origin, then became a substantive legal principle, and recently, solicitor-client privilege has been recognized as a constitutionally protected principle of fundamental justice for the purpose of Section 7 of the Charter. So, solicitor-client privilege has the highest status of any privilege you can think about because it's now recognized as a charter privilege or a privilege backed by the charter. Now, in the other hand, the duty of confidentiality originates from the code of conduct or the rules of professional conduct. At best, we can look at it more. It is an ethical principle originating from the code of conduct or the rules of professional conduct. At best, it may be said to have a common law origin, but this is in the context. We look at it in this way in the context of the fiduciary nature of lawyer-client relationship, because lawyer-client relationship is a fiduciary relationship, and in the fiduciary relationship, parties in the fiduciary relationship are obligated to protect confidences in that relationship. So one of the difference between solicitor-client privilege is the origin. Solicitor-client privilege and duty of confidentiality is the origin. One, that is the duty of confidentiality, has an ethical origin in the rules of professional conduct, whereas the other, which is solicitor-client privilege, currently is recognized as a constitutionally protected principle that protects information disclosed in the course of a lawyer-client relationship. The difference between solicitor-client privilege and duty of confidentiality can be looked at in terms of the scope of the two. The duty of confidentiality is very broad. And if you take a look at Rule 3.31 of the Law Society of Alberta Code of Conduct, take note it talks about the lawyer holding in strict confidence all information concerning the business and affairs of the client. All information concerning the business and affairs of the client. This is very broad. On the other hand, solicitor-client privilege is very narrow. Solicitor-client privilege only covers information, whether written or oral information, exchanged by the lawyer and client in the course of seeking or providing legal service to the client. So let me think of an example here. If a client walks into your office with a blood-stained shirt, and the client informs you that they have just committed murder, and they came to seek your legal representation because they know they're probably going to be arrested soon and charged. Now, if the client confesses to that murder or confession to that murder is information disclosed to the lawyer in the course of seeking legal advice, that confession is solicitor-client privileged. Now, how about the blood-stained t-shirts this client was wearing? Now, the blood-stained t-shirt is not an oral or written communication exchanged by the parties in the course of seeking or providing legal service. But that is your observation as a lawyer. That observation will come under the ambit of the duty of confidentiality. It is not solicitor-client privilege because it is neither written or oral information or communication. So this is important because it goes to highlight how broad the duty of confidentiality is and how narrow the solicitor-client privilege is. And that, of course, goes for that to highlight the difference between the two. So another difference between the two can be looked at from the source of the information. Solicitor-client privilege applies to information provided or exchange of information between the lawyer and the client. So it's important to note the source of the information. The information is coming from the client or from the lawyer, but not just from the client and the lawyer, but also the agents of these two. So the agents of the client in this case could be, for example, in a situation where the client has an interpreter. The interpreter is an agent of the client, or maybe the communication between the lawyer and the client. You have an interpreter exchanging the communication or interpreting the communication between the lawyer and the client. The interpreter in this case could be either the agent of the client or the agent of the lawyer. So information coming from the interpreter will also come within the context of the solicitor-client privilege. Another example I can think of here is maybe in the case of a corporation. A corporation is an abstract entity that is incapable of providing advice to the client or providing advice to the lawyer or receiving advice from the lawyer. So a corporation, being an abstract entity, acts through agents. So the agents of the corporation advise the lawyer and also obtains information or advice from the lawyer on behalf of the corporation. So what I'm trying to highlight here is that in talking about solicitor-client privilege, the exchange of information must come from the lawyer and the client or their agents. Information from third parties who are not parties in the lawyer-client relationship and who are not agents of the parties in the lawyer-client relationship is not entitled to solicitor-client privilege. Okay, now talk about the duty of confidentiality. In the case of the duty of confidentiality, the duty applies to information obtained by the lawyer about the client business and affairs in the course of the relationship. All information obtained by the lawyer about the client business and affairs in the course of the lawyer-client relationship. Here, it is irrelevant what the source of the information or where the source of the information the source of the information is irrelevant here. What matters is that the information relates to the business and affairs of the client, and it was obtained by the lawyer in the course of the lawyer-client relationship. So the lawyer has an obligation to protect those information. That's an obligation under the duty of confidentiality. So if that information came from a third party who is not a party to the lawyer-client relationship and who is not an agent of either of the party in the lawyer-client relationship, as long as that information relates to the business and affairs of the client and was obtained by the lawyer, even from a third party, in the course of the lawyer-client relationship, the lawyer has an obligation to protect those information. So that's another significant difference. With regards to solicitor-client privilege and the duty of confidentiality. Okay, now another important difference between the two lies in the significant legal differences between the two. Solicitor-client privilege is protected by charter. It is a constitutionally protected privilege. The duty of confidentiality is protected by ethical code, and at best, maybe in the case of a fiduciary relationship, by common law. And what is the implication of this? The implication relates to ability of the lawyer to disclose that information to a third party. Let me try to illustrate what I'm saying. Maybe going back to the example earlier of the client that has committed murder, came to your office with a blood-stained shirt, confessed to the murder. Now, let us assume in this context, you did not go ahead to represent that client. If that client subsequently retains another lawyer and that client is being um, prosecuted, let us assume in the course of the trial, you, as a former lawyer, of course, who did not agree to represent him, was compelled to come and testify. If in the course of trial you are asked questions about the confession made by the client when the client consulted you, you can rightfully object to answering those questions and invoke solicitor-client privilege, because the information relating to the confession or the oral communication made to you by the client is solicitor-client privilege. And because that privilege has charter backing, the court will accord high regard to it. So in this case, you can invoke that privilege and refuse to answer questions with regards to the confession made by the client. Now, in that example, I also talked about the bloodstained t-shirts which the client wore when they came for that consultation. Now, what you observe as a lawyer is not solicitor-client privileged. So if you are asked questions about your observation, you cannot raise solicitor-client privilege. Now, even though that information is protected by the duty of confidentiality, in this case, you may be obligated to disclose that information and will not be able to raise solicitor-client privilege to protect it. So what we're trying to highlight here is the fact that solicitor-client privilege has a higher legal standing when compared to the duty of confidentiality. So information protected by duty of confidentiality an individual can be compelled to disclose that information in court, whereas information protected by the duty of confidentiality, information protected by solicitor-client privilege enjoy higher privilege in court because they have charter backing or are protected by the charter. Now, one more difference between solicitor-client privilege and duty of confidentiality lies on the fact that all solicitor-client privileged information are confidential information, but not all confidential information are solicitor-client privileged. And what do I mean by this? Earlier on, I have indicated or stated the fact that the duty of confidentiality is much broad. Solicitor-client privilege is just a subset of that broader duty of confidentiality. So all solicitor-client privilege information falls within that duty of confidentiality because they are confidential information. But not all confidential information are solicitor-client privileged, because all confidential information outside the small subset of the broader duty comes within the duty of confidentiality, but it's not solicitor-client privileged. So all solicitor-client privilege information are confidential, but on the other hand, not all confidential information are solicitor-client privilege. The only confidential information that is solicitor-client privilege are those confidential information which were exchanged by the lawyer and client in the course of the lawyer-client relationship, whether they are written or oral. So let's go further now to talk about the similarities between the duty of confidentiality and solicitor-client privilege. And this is pretty straightforward. First is the fact that both duty of confidentiality and solicitor-client privilege are founded on the lawyer's duty of loyalty to the client. So they are an essential component of the lawyer's duty of loyalty to the client. Another similarity between the two lies on the fact that they do not exist outside legal relationship. The duty of confidentiality and solicitor-client privilege exists when there's a lawyer-client relationship. So it only arises from a lawyer-client relationship. However, they outlive the lawyer-client relationship because they continued even after the relationship have ended. Now, another important similarity between the two lies on the fact that only the client can waive the privilege or consents to the disclosure of the use of the information or confidential or privileged information by the lawyer. So here we are talking about in addition to the other exceptions, which we are going to consider in subsequent classes, that is the exceptions to the duty of confidentiality. Here we're specifically talking about waiving the privilege or the duty. The lawyer cannot waive the privilege. Only the client can waive or consent to the disclosure under the privilege or the duty. So remember, the lawyer is part of the relationship, but only one party in that relationship has the ability to waive the privilege or consent to the disclosure of the information, and that person is none other than the client. Another similarity between the two lies on the fact that they both outlive the relationship. Solicitor-client privilege and the duty of confidentiality last forever. They last indefinitely, irrespective of how the relationship ended. So, and this is important, especially when it comes to lawyers crafting undertakings for their employees. So it is important to impose this duty on the client also, to impose the duty on the employees, not for a particular term of years, but also indefinitely. So it doesn't matter if the staff have left your employment, that duty continues. That staff has an obligation to continue to hold that information in confidence for life. They cannot disclose it except under unless maybe the exceptions to the disclosure applies. Now we're going to be talking about those exceptions in subsequent class, so we will not go into the exceptions now. And that, of course, brings us to the final point with regards to the similarity. All these rules, whether duty of confidentiality or solicitor-client privilege, they are subject to exceptions. We will consider those exceptions in subsequent classes. So, so far we've talked about the duty of confidentiality, solicitor-client privilege. We've also talked about the differences and similarities between the two. Now we are going to proceed further by looking at the justification for preserving the duty of confidentiality, whether under solicitor-client privilege or under the ethical duty of confidentiality. Now, there are many justifications for this, one of which, of course, is the fact that it's the duty kind of serves to reassure the client that confidential information they provide in the course of seeking legal advice are protected and that the lawyer will not misuse such information to the detriment of, or will not use such information to the detriment of the client. So this puts the client in a better position to disclose the information and also at the same time enables the lawyer to be able to competently provide legal representation or legal service to the client. Now, the duty of confidentiality or the duty requiring the preservation of client confidences in this context also serves to balance the interests of the client and the justice system. It balances it in the sense that it enables the client to be able to disclose confidential information that will foster the truth-seeking objective of our justice system, while at the same time not detrimentally exposing the clients to loss of their privacy. So the client discloses the information to foster the truth-seeking justice of the truth-seeking objective of the justice system, while at the same time not absolutely sacrificing their rights to their privacy. And then undivided loyalty. So with regards to the undivided loyalty, the duty of confidentiality is very vital in facilitating a lawyer's duty of loyalty to the client. It facilitates the lawyer's duty of loyalty to the client by preventing the lawyer from profiting from the client's confidential information or from using such information to the detriment of the client or to the benefit of a third party. Because this is exactly what the duty of confidentiality prevents the lawyer from doing. So take away that duty of confidentiality, the lawyer will now have a very serious dilemma of maintaining the duty of loyalty to the client, because the lawyer will now be tempted, in some cases, to use this confidential information either for their own benefit or for the benefit of the third party or to the detriment of the client. So that duty kind of further helps the lawyer in discharging their duty of loyalty to the client. And of course, the final justification there, which is the fact that the duty serves broader societal interests, because it's important for people to be able to confide on individual, in this case professionals, when they are seeking information from such professionals, and this confidential information is vital to the provision of the advice they need from the professional. So these are some of the justification for the duty of confidentiality, or the duty to preserve client confidences. So what are the consequences for breach of the duty of confidentiality? Well, one is civil liability, and of course, this will remind us of the case of Zafar and Chodos, where a lawyer used confidential information obtained in the course of the lawyer-client relationship to commence an affair with the client's wife. Of course, the client was able to maintain an action and did recover damages from the client for misuse of such confidential information. Another consequences of the breach could be criminal liability, and this will apply in cases such as insider trading. And this is a situation whereby lawyers for corporations, use information, confidential information obtained from such corporations to trade in the shares of such corporation or other related corporations. So this is a case of insider information, of course, which relates to misuse of confidential information. So this will give rise to a criminal liability for insider trading. And of course, the inevitable, which is of course often the sanctions or disciplinary actions against the lawyer by the professional body, in this case the law society. So lawyers engage in misuse of confidential information or client confidential information will clearly be in breach of the rules of professional conduct. And where a lawyer breaches the rules of professional conduct, such a lawyer will be subject to, or may be subject to, disciplinary action by the law society. Now, another consequences of breach of duty of confidentiality, it's bad press. And here we're going to be talking about the Panama Papers, which is, of course, the Panama Papers scandal was, this is the, what would be the appropriate term here? The Panama Papers scandal was the worst case of breach of duty of confidentiality ever in the history of the legal profession. That scandal involved hackers who were able to gain access or hack the IT infrastructure of a law firm. They gained access to 11.5 million documents of more than 214,000 clients of the law firm. And what was unique about the Panama Papers is that these clients are not just your average citizens. The clients we are talking about here are wealthy clients, public officers, politicians, and even criminals who were using the services of this law firm to stash away and conceal their wealth in offshore accounts or offshore jurisdictions, and of course keeping them away from, some cases, from the tax authorities. So this cybersecurity breach or hacking resulted in the disclosure of this confidential information. And of course, these are the kind of confidential information the client definitely want to keep. These are the kind of information the clients, of course, involved here would definitely want to keep away from the public eye. So they are really confidential information. But this cyber hacking results in the disclosure of this 11.5 million document from over 214,000 clients. So one thing or one lesson learned from the Panama Papers incident is that the duty of confidentiality also extends to obligation on lawyers to take the necessary step towards cyber infrastructure, that is to secure the IT infrastructures they use in their law firm. And this case clearly highlights that. So the Panama Papers incident, of course, led to very bad press for the lawyer and for the law firm, and for the client also, which inevitably resulted, of course, in that law firm actually discontinuing its business. The law firm wound up, and that was the end of it. So security is becoming an important topic with regards to the duty of confidentiality, especially in the age of information technology. Now, we will now look at the duty of confidentiality with regards to physical evidence. And courtesy of the case of R. and Murray, it's important to note as a lawyer, your duty of confidentiality or your solicitor-client privilege does not extend to you as a lawyer, helping your clients to conceal physical evidence of a crime. The duty of confidentiality or solicitor-client privilege specifically applies to holding in confidence confidential communications. It does not entail or extend to physical evidence of a crime. And this was evidence in the case of R. and Murray. So a lawyer who conceals physical evidence from the client's crime will actually or may actually be found criminally liable for obstruction of justice. So you cannot assert solicitor-client privilege or confidentiality over the physical evidence of a client's crime. You are under obligation to turn such evidence over to the law enforcement agencies. That was what the lawyer in R. and Murray failed to do, resulting in the lawyer being charged, though not convicted, for obstruction of justice. So in conclusion, by way of summary, so far we have introduced generally the duty of confidentiality, which of course applies to protect all information obtained by the lawyer in the course of relating to the client's affairs or business obtained by the lawyer in the course of the lawyer-client relationship. We have also looked at the duty of, solicitor-client privilege, which we said is a charter privilege that protects communications exchanged by lawyer and client in the course of seeking and providing legal services. Did you take note of the differences and similarities between solicitor-client privilege and duty of confidentiality? Please take note of those differences and similarities. They are very, very important. And we have also seen the consequences of a breach of the duty of confidentiality. It will lead to civil or criminal liability, and of course, bad press or disciplinary action by the Law Society. So this is where we are going to stop today. In our subsequent class, we are going to look at the exceptions to the duty of confidentiality. So until then, thank you very much for your time, and I will see you soon. Bye.